And now we are moving towards a bit of south. Bulgaria and Romania is the two countries which we have. And then we are starting with Bulgaria, and I hand over the virtual microphone to Anna and Hristina.
Thank you very much for the kind introduction. Good morning to everyone from also rainy Bulgaria and Sofia. I'm very pleased to be here today with my colleague Hristina Dzhelekova, and we will cover briefly some insights of what we have witnessed in the last 6-8 months in Bulgaria, what companies were trying to address in COVID situation, what was the response of the government, and what are our tips on what steps you would need to consider to best prepare for the future. So like in other countries in CE and probably all over the world, companies suddenly woke up one day facing the challenge that they need to change the conditions they provide to employees while they're working, whether this is in the offices or in the production plants. And then what has to be done in order to really also meet the business needs of continuity of provision of services or production facilities. And the buzzword, which is in Bulgaria really very important and which established itself, is flexibility, and this word is here to stay. So flexibility in Bulgaria was needed in several aspects. Flexibility of working time. Companies had to take urgent measures to allocate employees into different time slots in order to avoid gathering masses at one time at one place. But also they needed to address the business needs and to allocate sufficient workforce and work time in order not to stop production or service that usually in Bulgaria outsourcing covers 24 hours, 7 days a week. Flexibility also came to the companies as a need in terms of working place. Our colleagues spoke about remote work from home. Indeed, this is the case for Bulgaria as well. It came easily the rule for lots of offices and office workers. And if we see the report from the Outsourcing Association in Bulgaria, IT and outsourcing companies have 97% of their employees working from home, and in September, only 14% have returned to work. The expectation is having very quite strong presence of international companies and US-led companies. Some of them are even planning remote work for most of the employees until mid next year. Flexibility also comes as balancing the work intensity. Particularly, it is relevant in sectors like production and manufacturing, where the labor-intensive work is involved and remote work is not at all as a solution. However, the flexibility had to be addressed and implemented in the context of the Bulgarian legislation, which in many instances is quite formalistic. The formality comes in several aspects. One of them is that for quite a few aspects of Bulgarian legislation, changing employment terms requires written consent from the employees. This is, for example, valid for implementing remote work or employees coming back to the office or establishing combined work regime. Part-time work or reduction of hours of work also would require consent of the employee. Other measures which the Bulgarian legislation, apart from written consent, would require, sometimes it requires prior internal rules and procedures and also consultations with the unions. This would affect implementing shift work and schedules, reduction of working time, also seizure of employees and changes of positions upon stopping a project or stopping of work of certain unit only. And also, we're talking about written consent. One would say, okay, we can implement e-signing. So digitalization is all over the world, and it is here. We in Bulgaria also are quite proud with broadband in spread, and people working from home easily. But e-signature is not that easy if the companies are not prepared. It requires prior internal policies and also consent. So some of these difficulties in order to address flexibility were addressed by the emergency legislation. This concerned mainly the possibility of the companies to implement work from home unilaterally, also closing part or whole plant operations without discussions with the unions, reduction of working time, also without consultations with unions, and also unilaterally imposing the use of paid leave by the employees. Having all these formalities, can you imagine IT company with over 2,000 employees really obtaining written signature for changing of any of the employment terms, or having production plant with more than 5,000 employees obtaining their consent, or also sending notification for certain changes? So let's see how the legislator addressed these needs of the business.
Thank you, Ani. Indeed, changes in the labor code was one of the most pressing topics that was discussed between the employers, between the business and between the government in the months during the COVID-19 situation, and it is still a hot topic on the market. There were many working groups, there were many suggestions to the government about changes that the business needs to be implemented, and that would facilitate facing that new environment. And I must say, because we took part in some of these discussions, that the government itself understood the need of such changes, because it was on several occasions, it was the case that even measures which are recommended by the government cannot be implemented by employers because of those strict formalities that need to be followed. So a few weeks ago, we had our draft bill announced, and that draft bill was faced by all stakeholders with a lot of interest and hope. I must say that when I reviewed the draft bill, I felt a bit disappointed, because most of the business needs and the business requirements addressed to the government were not actually reflected in the draft bill. Just to recap, the business had three main issues and three main requests to the government: to facilitate the remote work regime, and that would have been for the benefit of both employers and employees, because even employees enjoy working in that type of work, and they would need more flexibility as to the particular workplace. It does not need to be their home. But also employers need to balance their obligations in terms of health and safety, because how could you ensure health and safety conditions at any place in the world? And also they needed to balance the costs that need to be borne by the employer. Well, remote work was not at all addressed in the draft bill, and the government currently would not be changing anything in that regime. The second most pressing point by the business was the overtime. Bulgaria is one of the countries in Europe, one of the few countries in Europe where overtime is still prohibited. There are very limited and very narrow exceptions when companies can actually allow overtime, but they're so artificial that are never used and applied in practice. So sectors like the production, the various manufacturing companies, they wanted a bit facilitation of that regime in order to be practical and in order to help them cover ups and downs in their business flows. Over time, there are certain changes in the draft bill introduced, but they're very insignificant, and mainly the exceptions where overtime would be allowed are not changed. This means that any practical effect from that change will not be actually seen by the business. The third most pressing point that was addressed was to facilitate a little bit the schedule work and the shift work. As Anna mentioned, these are currently related to many formalities, many written documents to be exchanged. Communication with the employees should be formal, wet signatures are required, and so on. On that perspective, the draft bill is also insufficient. It provides for some changes, but they're not practical and not what the business actually needs. The interesting topic, however, in the draft bill, and the one that actually captured my attention, was that the government actually introduced changes which were not expected and were not part of the discussions with the business. And those changes relate to enhancing the participation of the unions in the communication between the employer and the employees. In the motives to the draft bill, the government noted that unions are not that much part of all these discussions and of all the changes that are happening even at company level, and that they see them as an intermediary, a needed intermediary to protect the social welfare of the employees. And also the government mentioned that they consider that collective bargaining agreements shall be more commonly applied. This is quite strange, but yet it shows the direction that the government thinks of, and something that may actually happen in the next months. The most pressing point here is at industry level, because the draft bill actually allows that collective bargaining agreement for a whole industry may become binding for all companies active in that industry, although they might not have been directly part in that collective bargaining agreement, and they might not have been part of the negotiations for that collective bargaining agreement. If this text actually comes into effect, I would expect that this may have a major impact in future. So what is the outcome for the business out of these discussions and out of the draft bill that is currently being considered by the parliament? It means only that the business shall be more active in its communication with the government, in being active in sending suggestions, formal suggestions, written statements, seeking for more meetings with the government in order for the business voice to be actually heard and reflected in any changes.
And in addition to being active during the legislative process, now before the second reading in the parliament, the discussion before various committees, this is the time the companies to enter actually those discussions and have their voice heard. In addition to that, what we would recommend: flexibility is here to stay, and how to ensure it. Probably the legislation will not change much. So the companies should use the time in advance, and first is to assess the working time that the company really needs and the working time options that the company is best suited for its operations to introduce. Whether this would be open-ended working time to avoid overtime, whether this would be summarized calculation of working time in order to adopt shift work, or opening the office hours and allowing employees to be a little bit more flexible for their 8-hour work within these office hours, or reduced working time when is needed to introduce also some reduction of the cost. But these measures require initial assessment, internal rules and policies, and also from time to time written consent. Talking about written consent, the next step is consider e-signing. E-signing indeed cannot be implemented from day one, but the companies can prepare for that. The e-signing would require first written consent from the employees, but let's say after that it would require adopting internal rules and procedures, which among others would also implement IT security measures related to storage and processing of the personal data of employees. We are not going to get into the GDPR, it's a big topic also related to employment, but these are measures which e-signing would require in addition to GDPR itself. Also, other measures would include internal rules, and Hristina, probably just to add to that.
Yes, in our experience from the previous months, what we actually saw is that many companies came to us saying that certain rules and provisions are already implemented in the organization, and they have been in the internal rules and the internal policies. And then when we came to the step that we would actually review those rules, we saw that basically these provisions were either not implemented or were vaguely implemented, or the rules and the policies were not known, were not notified to the employees. So often internal rules and policies, they are somehow neglected by companies, but from our perspective as lawyers, we see them as very important. Why? Because employers can introduce through such rules and policies many measures and many different types of options and regimes towards their employees, which will lead them to flexibility. For example, with the internal rules, You can provide more stringent IT security rules, more stringent disciplinary rules. You can digitalize some processes like paid leave applications and so on. And lastly, what employers need to know about the health and safety framework. This became particularly relevant now in the COVID-19 times. And what we would like to address to our clients and to any participants on that slot is that it is important employers to know what is their responsibility in terms of health and safety. Employers are responsible to implement adequate health and safety measures for their employees on the workplace during the working time. Employers are not responsible to track COVID-19 cases. This is all done and covered by the health authorities. Employers are not responsible to get information where employees travel during their leave and their spare time. And employers are not responsible to inform and contact the persons around an employee which might be infected with COVID-19. So in order to keep yourself safe on the grounds of health and safety, we have just three main tips, and these are: COVID-19 is a new risk, so you need a new risk assessment of the workplace. Health and safety requirements for the remote work seem to be quite complex and very specific, so consider preparing a policy specifically for the remote work. And third one is review and consider if your health and safety insurance policies are sufficient enough.
Well, Hristina, Anna, thank you very much for the lively discussion and very, very thorough analysis, even because of the very small time frame. And now we are immediately jumping to the neighboring country, and I hand over the word to Adelina and Andreea. Ladies, what about Romania?
Hello everyone. My name is Adelina. I am a counsel with Wolf Theiss Employment practice, and I'm together with Andreea. Andreea Stan is a senior associate with our employment practice here in Romania.
Hi everybody, and enjoy the rest of the webinar.
We are very happy to be part of this event and to share with those interested in Romania our ideas and experience. While exchanging information with our colleagues from the other Wolf Theiss countries as part of our regional projects, we actually concluded that Romania was quite well prepared to take the shock of COVID, both in terms of digitalization and employment legislation. Our presentation is therefore structured in three sections. We'll start with an overview of how is present versus past, and what were the employer's main challenges during this period. Afterwards, my colleague Andreea will continue with a short presentation of the main legal topics and challenges from a digitalization perspective, and in the end, a few tips and tricks. Short 2020 recap for Romania. What was already in place? We had a relatively good remote work legislation. In Romania, we have two sets of rules for work from home and for telework. We do not have now the time to make a complete comparison of these two types of remote work, but in principle, work from home is a very old concept. It was regulated in 1972 in the previous labor code. While telework is rather recent, enacted in 2018, and it deals with a combination of work from the offices provided by the employer and another place, be it the employee's home or another address agreed upon by the parties. Basically, what you should keep in mind is that Romanian employers were already familiar with remote work, and they were already using remote work prior to the COVID outbreak. We also had pre-existing legislation regarding quarantine leave, force majeure, and similar concepts that, as I will mention a little bit later, were basically never used before. We rarely had questions regarding such concepts before COVID. We had the possibility of the employer to unilaterally decrease the working time and the salary of the employee by 20% maximum, meaning 1 day per week. We had pre-existing regulation of technical unemployment with all the entire set of rules applicable, how is the employee being paid during this period and so on. And we had relatively modern flexi-time arrangements in terms of unequal working time, flexible overtime rules, flexible start and end hours. What was new in COVID context? We did not actually have a lockdown for employees in Romania. Work from home was never mandatory but only recommended, so employees could actually travel to the workplace during this entire period, including during the so-called lockdown in March and April, based on a affidavit provided by the employer. We had, as mentioned, the activation of these various concepts never used before in practice, quarantine leave and so on. We had implemented various job loss prevention schemes, primarily linked to technical unemployment, which basically required the suspension, 100% suspension of the employment contract. A little bit late in the process, but it's still good that we had it, because this helped for preventing additional dismissals. We had Kurzarbeit, short-time work, implemented in August, which allowed employers to reduce the working time by maximum and the salary by maximum 50% and to receive some subsidies from the state. We had parents' leave for during school's closure and later on online schooling paid from the state up to certain caps, of course. New health and safety rules, which were of course very challenging to implement, like social distancing at the workplace, body temperature readings and similar. And of course we encountered an increased pace of restructurings. What were the main legal challenges for employers, at least at the beginning until they get used to it? It was this overwhelming rhythm of legislative changes, but also various changes due to the fact that we could say that we had a conflict between legislative bodies. We had various government ordinances being repealed, being declared unconstitutional by the Constitutional Court of Romania. Employers encounter difficulties to implement 100% the telework legislation, especially once the emergency situation migrated into a state of alert, because during the first 2 months of emergency situation, employers could implement unilaterally work from home. We encountered employers had some difficulties, of course, to observe from a formalistic perspective the employment legislation in terms of execution of various documents, use of electronic signature, and so on. Various borderline interpretation of the scope and limitations of some concepts, of some new concepts, such as Kurzarbeit, and of course they had difficulties to comply with the new health and safety regulations. I'm now inviting Andreea to continue, and I will revert in the end with a few tips and tricks.
Hi, so thank you, Ade, for this and for passing the floor to me. Moving forward with our presentation, we wanted to give you some pointers on how digitalization impacted our awesome Romania. So when we look at the Romanian market before COVID, we see that we already had some tools that enable the implementation of remote work at a very fast pace in most sectors. With one of the fastest internet connections in Europe, and dare I say even in the world, and with the cost of telecom utilities being rather low, Romania, suddenly the remote office situation became very attractive, not only possible in Romania. As Adelina mentioned, we already had some relatively modern legislation on remote work, But to be fair, this was rather formalistic to be implemented before COVID, and the relaxed interpretation was given in the COVID context, which we welcomed, of course. But we also saw some very particular and non-regulated situations on flexi work arrangements being implemented by employers in their own internal policies. This meant that our people in Romania were already accustomed to the idea with working remote. So all in all, Romania was really well prepared to take the shock of COVID. But of course, with most, if not all of the employees of our clients working from home and with restrictions on movement in place, we also faced some challenges. As already mentioned throughout this presentation, implementation of remote office regulated situation, either work from home or telework, usually requires consent. But under the form of an addendum to the employment agreement, it's relevant to mention that. But how do you obtain such a consent if wet ink signature becomes difficult to obtain? We looked at whether e-signature legislation helps us, and we found that it is insufficiently performant to allow people to sign electronically. So similar to Bulgaria, wet ink signature is only equaled in legal effects by qualified e-signature tools, and most of us lack such tools. I myself don't have qualified e-signature. So what our clients did to address this issue was to usually sign in counterparts and to exchange originals via courier or post. This is what was done. Other challenges evolved around data protection restrictions. As you know, we have never faced situations of staying and working from home continuously for such long periods of time all together at the same time. So we come to think of HR dealings, which usually were happening face-to-face or offline, such as disciplinary hearings or professional and fitness hearings, which were suddenly happening online. So in cases like this, where it is really important, even crucial, to record the position of the parties, we come to think how to deal with that. So we advise our clients that, if they cannot obtain minutes of the meetings, as would happen usually in face-to-face meetings, with momentum being lost, employees are less and less prone to sign minutes of the meetings, to actually record the online meetings. When we look at the GDPR restrictions surrounding that, we came to a conclusion that what we advised our clients to do was, invite them to the meeting by sending accompanying notice whereby we inform them that it's best to record the meeting. We include a certain wording in the convening notice that can be replicated, carved out by the employee and replicated in an email confirming their consent, and have the same employees reconfirm consent online once the meeting started. This is what we did to address, to meet recording needs with GDPR restrictions. Moving on to my next point on the challenges sections, we saw that working from home can actually lead to some discussions on increasing costs on employers, with employees actually claiming that employers take part in some cost-sharing arrangements, either in the form of direct payment of cost of utilities or rent, or as payment of bonuses aimed at covering the same expenses. While some of our employees really had to have the talks with employees claiming that, to our knowledge, none of them actually gave in to such requests. We know that it is quite a hot topic in Europe as of this moment, and even some countries, if not made it mandatory, at least they're discussing on legislation regarding the implementation of some cost-sharing arrangements. But what have we learned? We learned that our country is quite digital literate and has an appetite for technology in most sectors and for most age groups. We also learned that remote work seems not only to work, but seems to become the run-of-the-mill rather than the exception, even absent some extraordinary situations such as the pandemic. So it sort of becomes the trend, even if before it was perceived as a benefit, just like my colleagues mentioned as well. We see that in the end, the remote office situation leads to less costs incurred by the employers, and with profits increasing. So all in all, it makes us look at the definition given by the European Parliament to smart work some while back, I think in 2016 or something like that, as an approach to organizing work through a combination of flexibility, so all of this mechanism thought of by the employers, autonomy of the employee who can work from whatever and whenever, and collaboration, which means transparency and the good relationship between employers and employees. So that's it from the digitalization perspective. Moving on to some legal tips and tricks, I'm sure Adelina will keep your attention focused for some moments.
I'll be very brief. So, of course, there are so many legal tips and tricks that we could list here, but we limited ourselves to these four. The first one is obviously very, it's very obvious, and it's applicable to all countries, I guess, is to implement state-of-the-art internal policies. We always recommend our clients to evaluate what needs to be contractual and what can be kept unilateral, because of course this is the best way from employer's perspective to be able to amend whatever rule implemented whenever they want without the consent of the employees. The second tip would be to not forget about data protection and to basically validate all employment measures that are being implemented from a data protection perspective. Since we are dealing with employees, of course, data protection remains relevant at any point in time in relation with any policies. The third one would be to try to evaluate and to transfer what is possible in terms of health and safety risks, responsibilities, liability from the company to the employees. Of course, we are aware that this is not 100% possible. Maybe it is possible to a very limited extent, but it's still valuable to evaluate what can be done here. And via what tools, maybe contractual or maybe unilateral. And lastly, to consider the permanent establishment risks in situation of remote work, because as Matthias, I think said, there are indeed many situations when the employees could work from other countries without the employer even knowing, or there may be situations when the employee asks to work abroad and the employee agrees without considering the fact that this may lead to the risk that a fiscal permanent establishment is created in that country.
Well,
my side, from our side, and we are also to questions.
Yeah, thank you again. Similar to Bulgaria, I'm very glad one. Lots of things going on in Romania. We can see clearly. The question is in connection is posed to Romania, and in connection with the last topic you actually touched, Adelina, is what if the employee actually decides to change the place of work unilaterally or even leave the country, but still performing the work in an excellent way? How to deal with that situation? Should the employer do something? Is there any consequences on the employee?
Strictly from in light of the current legislation, the location where the employee works should be agreed by the parties in case of all situations of remote work, mainly telework, because this allows work from other locations than the employee's home. So this is the current situation. So of course, with the consequences can be the standard one. This could lead to the liability, to the disciplinary liability of the employee, or to the contractual liability of the employee in terms of damages and so on. But we really believe that this globalization of labor force is the trend, and that at some point we'll reach to that. We are already on this track for sure, and we really believe that employers and also legislative bodies should adapt to this new reality and should find ways to mitigate this and to allow basically employees to work from wherever they want.
And if I may jump in just 1 second, from an HR perspective, I believe that employers should encourage their employees to come forward and not to be afraid of this, because if this is the trend, then we should adapt to it. We shouldn't prevent it or prohibit it.